Welcome to the 2025-2026 SCOTUS preview with Dean Erwin Chemerinsky and Kimberly Atkins Stohr. I'm Rachel Kogan, the chair of BHBA's litigation section, and I would like to start off by thanking the National Association of Women Lawyers for co-sponsoring today's program. NAWL's mission is to provide leadership, a collective voice, and essential resources to advance women in the legal profession and advocate for the equality of women under the law. BHBA and NAWL have many members in common, and we look forward to continuing to partner. Now, I am very delighted to introduce our speakers, Dean Erwin Chemerinsky and Kimberly Atkins Stohr. Both really need no introduction. I know you want to get right to their discussion of the Supreme Court term, so I will keep their bios brief, especially knowing all of their comprehensive information is in your materials. Dean Erwin Chemerinsky is the Jesse H. Chopper Distinguished Professor of Law and Dean at Berkeley Law, and was previously Dean at UC Irvine School of Law. He's one of the country's most respected constitutional law scholars, advocates, and speakers, the author of 19 books and hundreds of law review articles. Kimberly Atkins Stohr is a senior opinion writer and columnist at the Boston Globe. She is an on-air political analyst for MSNBC, a frequent panelist on NBC's Meet the Press, and co-host of the popular Politicon legal news podcast, Sisters-in-Law. Before launching her journalism career, she was a civil trial and appellate attorney in Boston. Erwin and Kimberly, over to you to tell us about what we should expect from this October term of the U.S. Supreme Court. Thank you so much.
Rachel, thank you so much for the kind introduction. It's really an honor and pleasure to do the program again, and it's terrific to get to do this with Kim. What we're going to do is each offer some overview thoughts about the Supreme Court, where it is now and where it's likely to go, and then we're going to take up several topics. We'll talk about elections and the political process. We'll talk about tariffs. We'll talk about the removal power, and then we'll talk about cases that most easily being thought of as culture war ones before the Supreme Court. We'll take turns presenting and commenting, and we'll save a few minutes at the end for questions. So let me just begin with a quick overview. For the last 5 years, at the end of each Supreme Court term, I've written a book for the American Bar Association, recapping the cases and talking about their significance. I try to find a theme in the decisions and have it reflected in the title of the book. Sometimes it's easy. Remember the term a few years ago where the Supreme Court overruled Roe versus Wade, dramatically expanded gun rights, significantly changed the law with regard to the religion clauses? I just titled that A Momentous Year in the United States Supreme Court. My title for the book on last term was Taking Sides. Our country is more ideologically divided than it's been at any time since Reconstruction. Many of the cases last term reflected that ideological divide. They came from the so-called culture wars. They involved challenges of President Trump's initial actions after being this term in office. Almost without exception, the Supreme Court came down on one side, the conservative side of that ideological divide. Now, you may agree with what the Supreme Court was doing, or you may disagree with what the Supreme Court was doing, but I think there's no doubt that it was a term of taking sides. It's certainly perceived that way. There was recently a Gallup poll that showed that of those who self-identify as Republicans, 75% approve of the Supreme Court's performance. Of those who self-identify as Democrats, 11% were approving the Supreme Court's performance. It's the largest gap as long as it's been measured. I think the profound question, as we think about the Supreme Court this term and the foreseeable future, is at a time when our country is so deeply ideologically divided, what will it mean to have a court that's perceived so clearly, solidly on one side of the ideological divide? A few statistics about last term as we think about this term. Last term, the Supreme Court decided 56 cases with signed opinions after a brief and oral argument. In the 1980s, the court was deciding about 160 cases a year. In William Rehnquist's last term as chief, October term 2004, the Supreme Court decided 85 cases. To go from 85 let alone 160, down to 56, is truly notable. Even more stunning was the increase in the number of rulings on the Supreme Court's emergency docket, its so-called shadow docket. In October term 2023, just 2 years ago, the Supreme Court had 40 matters that it resolved on its emergency docket. For October term 2024, it was, as of June 27th, the last day opinions were resolved, 113 matters, and overall for the term, 144 matters. That means the number of matters on the emergency docket tripled over the course of a year. To me, there's much that's troubling about the Supreme Court shadow docket. How the Supreme Court is implicitly overruling long-standing precedent. How the Supreme Court is now treating its rulings on the shadow docket as binding on lower courts. Maybe most of all, I'm concerned that the Supreme Court is often handing down crucial rulings, including ones affecting life and death, without a word of explanation. But I do think one of the most important developments as we go forward is how the emergency docket of the Supreme Court has transformed in what it means for the court and for society.
Well, thank you, Erwin. It's good to be back with you here again. I agree with your assessment, your opening assessment about where the Supreme Court is in this term and where we've come from. I will just add a few more themes when I'm thinking about the overview of this term. And it really is about power. That's the overarching issue. One of the biggest themes is presidential power. Several cases we're going to talk about really get to the heart of the Supreme Court having an opportunity to really embrace the so-called unitary executive theory, this idea that the President of the United States, when it comes to matters of the executive branch, is the decision maker. And a lot of the checks and balances that were put in place to sort of share that power among the other branches are being eroded, and the Supreme Court could come in and really tear them down completely to make the office of the president as powerful as it's ever been under our current president. I also have been thinking a lot about the power of the other branches. It's really hard to elevate the power of the executive without really whittling away the power of, for example, the legislative branch. Now, Congress has is in the process, in my opinion, of abdicating a lot of that power themselves. But the Supreme Court is providing a powerful assist in that endeavor. And it's also about the power of the court itself, not just as the judiciary in the power, because in some cases, when you broaden executive power, you reduce the power overall of the judiciary to a large extent. But it seems that the Supreme Court is doing it in a way to preserve its own power while really whittling away the power of the appellate and trial level federal courts in the process. The Supreme Court is finding itself through the shadow docket that Erwin talked about, increasingly at odds with lower courts that seem to be putting in place injunctions, for example, against certain presidential actions, while the legality or constitutional issues that are raised by such actions are worked out, putting a pause on them. But the Supreme Court has repeatedly gone on to lift any stays that were put in place, increasingly saying that there is an interest, the potential damage that could be done to the president by not allowing him to carry out his objectives is greater than the negative impact that it could have to the other parties in the case. I see that as an alarming theme that is happening with this court too. And finally, I have written a little bit about my concerns about the erosion of stare decisis. As a law student, stare decisis really was presented as a crucially important principle to provide stability and reliability in the law, just to make society work and to make democracy stronger. And it seems the Supreme Court is very, very willing to upend past precedent just because they disagree with it, which isn't the standard that I learned in law school. So those are some of my opening thoughts as we dive into the cases cases this term, and I think I am going to start in that endeavor by getting into some of the cases related to democracy and elections. And the biggest one is a case called Louisiana v. Calais, which is a opportunity for the Supreme Court not only to revisit a map of Louisiana, a congressional map that was drawn in an effort to adhere to the Voting Rights Act, but the Supreme Court may take out a significant part, one of the remaining functioning parts of the Voting Rights Act while we are at it. So I want to go back first to 2022 when the Supreme Court decided a case called Allen v. Milligan. Now, at that time, I and others were watching that case closely, worried that the Supreme Court may strike down or effectively nullify Section 2 of the Voting Rights Act. Section 2 is the section that allows individuals to bring claims to enforce the Voting Rights Act based on claims that there are racially discriminatory voting practices put in place. For example, in that case, it involved a gerrymandered map in Alabama. There was concern that the Supreme Court would not only strike the map down, even though it was drawn in a way to try to adhere to the Voting Rights Act, but that, as I said, it could overturn and nullify parts of Section 2. But they didn't. They actually applied Section 2 and found that that Alabama map was indeed an illegal racial gerrymander under that because it packed Black voters into a single section in a way that diluted their votes. Well, several states after this ruling, including Louisiana, adopted new congressional maps with that in mind, trying to adhere to the Voting Rights Act. And one of those states was Louisiana. Black voters had sued because at the time, although Black residents made up about a third of Louisiana's population, there was only a significant number of them in one of its 6 voting districts. They sued, alleging that that was an unconstitutional racial gerrymander, packing them into one district. And they won. There was a new map drawn that created 2 Black opportunity districts. Now, what that means under the Voting Rights Act doesn't mean that Black people can for sure get the candidate that they want or that they get an additional Black candidate. It's misunderstood in that way. What it means is there's enough of them in a district that there are other parameters too, that it's sort of naturally configured, that it keeps communities together, and other factors just to show that it's not just a completely the kind of gerrymander you think about in a long drawn out district, but that it is a way to ensure that they have a real opportunity to select the voter, a candidate of their choice. And in these cases, 2 of these districts were made up of at least 50% Black voters in that state. Well, a group of self-described non-African Americans then sued over the new map, stating that it violated the 14th and 15th Amendments of the Constitution. The 14th Amendment provides that there shall be equal protection under the laws, and the 15th Amendment prohibits discrimination in voting on the basis of race. These are Reconstruction amendments that were put in place at the time in order to ensure that Black people after the Civil War were able to become fully functioning members of society. And so that case is now before the Supreme Court for the second time. It was before the court last term, and rather than issuing an opinion, they put the case back on the docket this term and held arguments earlier this month. Based on those arguments, it seems pretty clear that these Voting Rights Act, if Section 2 is not actually overruled as unconstitutional, it will be severely whittled down to almost nothing. 2 of the people who were in the court's majority in that Milligan case that upheld the Alabama map, Chief Justice John Roberts and Justice Brett Kavanaugh, both seem to cast real doubt that they would come to the same conclusion this time. John Roberts has long since the Shelby County case, Shelby County v. Holder back in 2013, 2012, Erwin, am I forgetting which one?
2013.
2013, that was close. It struck down Section 4 and nullified part of Section 5 of the Voting Rights Act. This was a pre-clearance requirement that in districts that had a long history of creating racially discriminatory maps or imposing other racially discriminatory laws had to get their plans pre-cleared by the federal government, the Justice Department, before they could be put in place. And rather than with Section 2, people can sue after an alleged discriminatory law is already put in place. Well, that was struck down in part because John Roberts felt that the perpetual formula that was in place to determine what districts were covered could not be, the plaintiffs could not show that those factors were still in place at the time. It wasn't a clear time limit, but it seemed clear that the point of the Chief Justice is, look, just because there was racism to be found in the past, we cannot continue perpetuating it. The way to stop discrimination by race is to stop discrimination by race. Well, Brett Kavanaugh seems to have joined that view. He asked a lot of questions about time limitations within this. And he pointed to other cases, such as the affirmative action case, which the Supreme Court took what I believed was dicta from the late Justice Sandra Day O'Connor in a previous case that said she hoped in 25 years that affirmative action would no longer be necessary to create diverse student populations as a deadline. And the Supreme Court, 22 years after that decision, struck down affirmative action entirely, was really asking about what the time limit on racial discrimination laws or the use of race in rectifying racial discrimination under the VRA should last. So to me, that points to a likely victory on the part of the non-African Americans and severe damage to the Voting Rights Act. I'm just going to flag a couple other election-related cases quickly. One is called the National Republican Senatorial Committee versus the Federal Election Committee. This could be the biggest campaign finance case, I think, since Citizens United was decided back in 2010. In this case, the court will consider one of its past precedent. We talked about stare decisis there in Federal Election Commission v. Colorado Republican Federal Campaign Committee. That 2001 case upheld federal limits that prevents campaigns from coordinating with outside political parties. Things like super PACs are not allowed to, they're allowed to spend money in federal campaigns, but they're not allowed to coordinate with campaigns. This case could challenge that and could very likely strike that distinction down on a First Amendment claim. That was the same basis in Citizens United that the court really opened outside spending and striking down those limits in federal campaigns. So I would keep an eye out for that. There's also a case called Bost v. Illinois State Board of Elections. That case is about standing. Who has the right to sue over election rules, such as, in this case, Illinois' mail-in voter law? One candidate who says that the law would make a difference in the way candidates run their election want to bring to state that he has standing to challenge that case. I think the court will likely find standing. I'm not sure that that will have a huge impact. I think most cases will find that candidates would have that too. I don't think that's going to open the floodgates, but I do think the other two are really important and worth paying attention to.
Thank you. I just wanted to comment on Louisiana versus Calais. I so agree with Kim that I think this is one of the most important cases on the docket, and it could be one of the most important civil rights cases in decades. I regard the Voting Rights Act of 1965 as one of the most important federal laws adopted in my lifetime. In 1964, in Mississippi, only 6.7% of eligible Black individuals were registered to vote. That was in a state where almost 70% of white individuals were registered to vote. In Alabama, only 19.5% of eligible Black individuals were registered to vote. Across what we regard as the South, the states that comprise the Confederacy, less than a third of eligible Black individuals were registered to vote, where again, more than twice as many as white individuals were registered to vote. The Voting Rights Act changed that and changed that rapidly. By 1966, in almost all of the states that comprised the old Confederacy, more than half of eligible Black voters were registered to vote. And there were two key parts to the Voting Rights Act, is what Kim was talking about. One is Section 5 that required preclearance. It said that before a jurisdiction with a history of race discrimination could change its election system, it needed approval from either a three-judge federal court or the Attorney General of the United States. Hundreds of instances of proposed voting changes were denied pre-clearance and didn't go into effect because of the discriminatory impact. In Shelby County versus Holder, as Kim said, the Supreme Court effectively declared pre-clearance unconstitutional and therefore nullified Section 5 of the Voting Rights Act. But in the Shelby County case that Kim mentioned, Chief Justice Roberts said, well, don't worry, we still have Section 2 of the Voting Rights Act, which says that state and local governments can't have election systems and practices that discriminate based on race. In 1982, Congress amended this to say that proof of a discriminatory impact was sufficient for liability. There didn't have to be proof of discriminatory intent.
Right.
Kim described how this case presents to the Supreme Court the question of whether Section 2 is unconstitutional, whether Section 2 is going to get limited by the court. I would just offer two comments about this. One is, why should the passage of time matter? Kim rightly points to what Justice Kavanaugh said at oral argument and what he said in a concurring opinion, Allen versus Milligan, that maybe so much time has gone on, we don't need the Voting Rights Act anymore. But why is that for the Supreme Court to decide, and on what basis? I'm reminded that in 1883, in the civil rights cases, just 18 years after the end of the Civil War, the Supreme Court struck down the Civil Rights Act of 1875 and said, it's time to get past slavery. It's time to get past the need for remedies for racism. There's this constant temptation to say the problem is over when it's clearly not. But second, I want to say why I think this case could be important beyond voting rights. In 1976, in Washington versus Davis, the Supreme Court said that proof of a racially discriminatory impact isn't sufficient to show race discrimination. There has to be proof of discriminatory intent. It's very difficult to prove discriminatory intent. Rarely do legislators or policymakers openly express a racist motive. Also, we know a lot now about implicit bias and unconscious racism. That's why there's a number of federal statutes that allow for liability on proof of disparate impact. Title VII does this in employment discrimination. The Open Housing Law does this with regard to housing. And 1982 amendments to the Voting Rights Act. On August 1st, the Supreme Court in Louisiana v. Clay asked for new briefing and argument on the question of whether Section 2 of the Voting Rights Act is unconstitutional, is violating equal protection. The argument is that in order to avoid disparate impact liability, decision makers have to consider race, and that would violate equal protection. In fact, on June 27th, Justice Clarence Thomas did something I've never seen before. When the court set the case over for re-argument, Justice Thomas dissented and said he would just declare Section 2 unconstitutional. But this isn't just limited to voting rights. In 2009, in a case Ritchie versus DiStefano, Justice Scalia wrote a concurring opinion where he argued that under Title VII employment discrimination, disparate impact would be unconstitutional because it would require decision makers to consider race to avoid liability, and he thought that violated equal protection. Yeah. So the court's narrowing and validating Section 2 and disparate impact would be devastating for voting. But if the Supreme Court says that disparate impact liability violates equal protection, it will put in jeopardy Title VII, the Fair Housing Act, and state laws that allow disparate impact liability. Should I talk briefly about the next area, tariffs?
I think so.
Next Wednesday, the Supreme Court's going to hear oral arguments in two cases regarding President Trump's legal authority to impose tariffs. These are Learning Resources versus Trump and VOS Selections versus Trump. President Trump now has imposed over $1 trillion in tariffs. And the question is, does he have the legal authority to do so? President Trump is claiming that the International Emergency Economic Powers Act gives him the authority to impose tariffs. In the first of the case I mentioned, Learning Resources, the United States District Court for the District of Columbia said that the statute doesn't give the power to impose tariffs. Before the D.C. Circuit could hear the matter, the Supreme Court granted review. It's unusual for it to do so, but not unheard of. It's called certiorari before judgment. And then subsequently, in the other case I mentioned, VOS Elections versus Trump, the United States Court of Appeals for the Federal Circuit, in a 7-4 en banc ruling, held that President Trump lacked the authority to impose most of these tariffs. So the primary issue before the Supreme Court is one of statutory construction. Does this statute give the president the power to impose tariffs? The two lower courts said the statute doesn't do that. The statute gives the president the power to, quote, regulate importation in an emergency. The lower court said where Congress wants to give the president the power to impose tariffs, it uses the word tariffs or a synonym. This statute doesn't do so. Also, the challengers say there's a difference between giving the government the power to regulate as opposed to the power to tax. And then there's the underlying issue. Is there really an emergency here? President Trump is saying that it's clear that the power to regulate importation is the power to impose tariffs, whereas the challengers are saying, no, if you look at the plain text of the statute, tariffs just isn't there. There's also an issue with regard to the administrative state. In recent years, the conservative justices, in a series of 6-3 decisions, have said that the executive branch of government can't act on a, quote, major question of economic or political significance without clear guidance from Congress. You might remember just a couple of years ago in Biden versus Nebraska, the Supreme Court 6-3 invalidated President Biden's student loan relief program, saying this is a major question and Congress hasn't been sufficiently specific. The Federal Circuit said tariffs are a major question of economic and political significance, and Congress hasn't been sufficiently specific in giving the president this authority. The president claims that he has the authority under Article 2 of the Constitution, because this relates to foreign policy. The counter-argument, of course, is Article 1 gives to Congress the power to tax, and tariffs are a form of tax. I found most interesting in the Solicitor General's brief the explicit statement that the courts shouldn't be able to review the tariffs at all, that the courts should just leave this to the president in the political process. That's, of course, the same argument that the Solicitor General is making with regard to the president's use of troops in cities, that there can be no judicial review. Just to conclude, what I find interesting here is if the conservative justices follow their traditional principles, this should be an easy case for them. Conservative justices say, follow the plain text of the statute. The text doesn't mention tariffs. The conservative justices say, the executive branch can't act on major questions. These are major questions. On the other hand, it is a court majority that's been very deferential to the president, and so the appeal of the Solicitor General to just leave this to the president might resonate with some of those justices.
Yeah, Erwin, I think you're exactly right. I am not certain. Usually, in cases like this with challenges involving the president, I think the odds are in the president's favor. But in this one, I'm not so sure for the reasons that you pointed out, including the strict statutory construction argument really works against the president here. One thing that I just found interesting about the brief by the Solicitor General, too, was that it echoed what Donald Trump has been messaging, which is we need the tariffs or we're not going to have a country. There will be an economic collapse if these tariffs are overturned. The country just wouldn't survive it. And economists, including people who are conservative from places like the Cato Institute, are saying that's actually not true. The president is exaggerating the impact of this. Yes, they will feel it. It would be a significant loss of revenue, but the government can make that up in other ways, and historically it also has. So it really cuts against this idea that there is an emergency. I think that President Trump, I like to call him the president who cries emergency, because he's declared emergency power to do all sorts of things. By and large, the Supreme Court has allowed him to get away with it, at least as the challenges move forward. But this is one that I think could be a place where they say stop.
I just want to highlight one thing that you said. I found looking at the amicus briefs particularly interesting because
Mm,
so many traditional conservative groups
mhm.
are against President Trump on this.
Yeah.
So I'm not surprised the Chamber of Commerce is against the tariffs, but this is a court that's very receptive to arguments from the Chamber of Commerce. The Washington Legal Foundation, you mentioned the Cato Institute, the Goldwater Foundation. All of these are groups that would traditionally be on Trump's side. And it'll be interesting whether that has some influence in the justices. There are far more amicus briefs against the tariffs than there are in favor of President Trump's position.
Yeah, that's really interesting. So I'm going to say a little bit about the removal power cases. One key feature of President Trump's second term is his desire to fire leaders of federal agencies based on his policy differences with them or some other reason. He sees, and the government is now arguing that the president, as the head of the executive branch, has the authority to hire and fire his subordinates within that branch. Again, a broad reading of the unitary executive theory. But federal law and Supreme Court precedent can put some limits on that. It has put some limits on that. Some agencies, if they were deemed to be quasi legislative or quasi judicial or quasi private, the court has previously held that there are some limits on the president's ability to fire the heads of those agencies based on the language of the federal law that created and governs them. Still, three times this year, when the president moved to fire heads of agencies, despite federal law that clearly stated that he cannot do so without cause, the Supreme Court, on its emergency docket, lifted stays that were put in place by lower courts that allowed the president to carry out those firings, at least in the short term, until those cases continued in the challenges in those cases continued through the appellate process. One of these was a shadow docket order in the case called Trump v. Wilcox, in which the court allowed Donald Trump to remove a member of the National Labor Relations Board and the Merit Systems Protection Board. And in lifting the stay that had kept them in place, the court, the majority of that order, reasoned that they exercised the fired heads exercise, quote, a significant authority and it reflects the judgment that the government faces a greater risk of harm from an order allowing a removed officer to continue exercising the executive power than a wrongfully removed officer faces from being unable to perform her statutory duty. Now, think about that for a minute. The court has already laid down the gauntlet and said, we see that in this fight, it is a greater harm if the president cannot fire whom he chooses than it would be to the people who are actually being fired. I would remember that as we're watching these cases. And this also seemed to conflict with yet another precedent, a nearly centuries old case called Humphrey's Executor. This stemmed from President FDR's attempt to fire the head of the Federal Trade Commission because he didn't agree with him on policy. But the statute creating the FTC and its leadership said that the officer could only be fired for cause. So William Humphrey had challenged his firing. Well, he passed away, but his estate, which is why the case is called Humphrey's Executor, sought back pay for his firing and won. And the Supreme Court said at the time, because it is an agency where Congress established this rule, that created it, that made it quasi-legislative, and that he could not, for no reason, fire someone. Well, that case suffered a huge blow with the Wilcox over it, the Supreme Court on a shadow docket case did not expressly overturn Humphrey's Executor, but that order was a pretty strong nail in Humphrey's executor's coffin. So now there is a chance for the court to do what it failed to entirely do in the Wilcox case, and that comes in a case called Trump versus Slaughter, which basically has the exact same facts as Humphrey's executor. You have a FTC administrator who has been fired by the president for no reason other than he doesn't like her policy. She fought it. She was removed from office. The Supreme Court allowed her to be removed, but the case is still making its way to the court. I don't think it looks good. One interesting thing in that Wilcox order, though, is that it's the court stated, now people are worried about the Fed. They're worried about the Federal Reserve. We don't think that the Federal Reserve is the same. Clearly, they're a semi-private, quasi-private organization that has nothing to do with the FTC. So that sort of laid down the gauntlet, that where the Supreme Court may draw the line on the president's authority. And sure enough, the president tried to fire a member of the Federal Reserve, Lisa Cook. And that case is also before the Supreme Court as she fights that case. I'm not going to make any predictions on that one, Erwin. Maybe you will, but it would be interesting to see after that Wilcox note how they get around saying that the president can uh, fire Lisa Cook, and which could in turn also mean that it can fire the chair of the Federal Reserve Bank, Jerome Cook. I'm told on good authority that Jerome Cook is not worried about losing his job. So we'll see how this plays out. It's looking good for Lisa Cook, but I'm still not going to make a prediction here, Erwin.
I'm always reluctant to make predictions. I long ago learned that he who lives by the crystal ball has to learn to eat ground glass. But I will point to a fact that distinguishes the two cases that might be relevant in making a prediction. With regard to Slaughter, the Supreme Court stayed the preliminary injunction that would have restored him to office. So he's been fired while this has been litigated. With regard to Cook, the Supreme Court did not stay the
Right.
preliminary injunction, and she's
That's right.
allowed to stay in office while this is being litigated.
That's right.
That's at least some indication that the justices see a difference between this. Um, I want to put these cases in a larger context, and that's they ultimately relate to the so-called unitary executive theory. The unitary executive theory is a theory developed early during the Reagan presidency by young lawyers, including John Roberts and Samuel Alito, that the president is in charge of the entire executive branch of government. In January 2006, when Samuel Alito was nominated for the Supreme Court and considered by the Senate Judiciary Committee, many of those who testified against him, including me, focused on his support for the unitary executive theory. It was very frightening to think that the president is going to have total control, unlimited by Congress, over the executive branch of government. Humphrey's executor, as Kim says, was cited in 1935. It's been followed ever since. But when President Trump took office, he said he believed that Humphrey's executor was wrongly decided. It's a unitary executive, and he can fire anyone in the executive branch of government. When the Supreme Court first considered the unitary executive theory, it was in a case Morrison versus Olson in 1988. It involved a law adopted after Watergate, the Ethics in Government Act, that allowed for the appointment of an independent counsel when there are allegations that the president or high-level executive officials had engaged in misconduct. It only allowed removal of the individual for cause. And the question is, did this violate the unitary executive theory? The Supreme Court, 7-1, expressly rejected the unitary executive theory. Chief Justice William Rehnquist, no liberal, wrote the opinion for the court and talked about how the Constitution creates interdependent branches of government, not independent ones. Only Justice Antonin Scalia in his dissent expressly embraced the unitary executive theory. Now I think we have a majority of the justices who regard Justice Scalia's lone dissent as the appropriate law. In the Slaughter case that Kim was talking about, the Supreme Court's granted review in two issues. One is whether Humphrey's executor should be overruled. That would be dramatic in itself. But let me read you the second issue the Supreme Court has granted review on, and that is whether a federal court may prevent a person's removal from public office, either relief at equity or at law. And what the Trump administration is saying is the president can fire anyone in the executive branch, and no court can overturn that or restore the person to office. This would not only mean being able to fire agency heads, but it would seemingly make civil service unconstitutional, protections that have existed since the 19th century. Should I move to what I call the culture war issues?
Let's get into it.
Let me, before talking about the cases that we've identified as cultural issues this term, talk about a case that came down on Wednesday, June 18th last term. Because I think to understand the cases on the docket this term, we need to start with United States versus Scrimetti. United States versus Scrimetti involved a Tennessee law that prohibited gender-affirming care for transgender youth. This was about prohibiting puberty-blocking hormones or cross-sex hormones for transgender youth. Federal District Court issued a preliminary injunction saying this is likely unconstitutional. The District Court said this is sex discrimination and also it's discrimination based on gender identity. The District Court said intermediate scrutiny is the appropriate test. Under intermediate scrutiny, a government action is constitutional only if it's substantially related to an important government purpose, and there has to be a searching inquiry by the court to make sure the law serves an actual important purpose. The United States Court of Appeals for the Sixth Circuit reversed. Chief Judge Jeffrey Sutton wrote the opinion for the court, and he said great deference should be given to the Tennessee legislature, only rational basis review, and the Sixth Circuit upheld the law. The Supreme Court, in a 6-3 decision, affirmed the Sixth Circuit and upheld the Tennessee law. Chief Justice John Roberts wrote for the court. There were concurring opinions by Justice Thomas Alito and Barrett. Justice Sotomayor wrote a vehement dissent, joined by Justices Kagan and Jackson. Justice Kagan wrote her own short dissent. Chief Justice Roberts began his opinion and stressed the need for deference to the political process in Tennessee. He said, this isn't sex discrimination because the law treats boys and girls the same, preventing gender-affirming care for either. And he says, this isn't gender identity discrimination. He relied on a 1974 Supreme Court case, Geduldig versus Aiello. That involved a California law concerning what disability benefits would be provided to state employees for medical conditions. And California provided disability for all medical conditions except for pregnancy. And the question is, was excluding pregnancy sex discrimination? And the Supreme Court, in an opinion by Justice Potter Stewart, said no, it's not sex discrimination. He said there's two categories of persons, pregnant persons and non-pregnant persons. He said since women are in both categories, it can't be sex discrimination. Likewise, Chief Justice Roberts in Scrimetti said there are two categories of people with regard to receiving these hormones. There are those who receive the hormones for other than gender-affirming care. And he said this includes transgender individuals. And then there are those who receive this just for gender-affirming care. These are transgender individuals. But since transgender individuals are in both categories, it can't be discrimination based on gender identity. Justice Sotomayor strongly disagreed. She disagreed with the premise. She said this shouldn't be an instance of deference to the political process. That at least since 1938, in the Caroline Products footnote, it's always understood that courts have a special role in protecting so-called discrete and insular minorities, groups that can't and likely to protect themselves in the political process. Transgender individuals are such a group. She says this is sex discrimination. There's drugs that can be given to boys that can't be given to girls, and drugs given to girls that can't be given to boys. If a boy has delayed puberty, he can give testosterone to enhance his male characteristics, but a girl who's transitioning can't be given testosterone to enhance male characteristics. If a girl has delayed puberty, she may have estrogen and other hormones to enhance female characteristics, but a boy who's transitioning can't be given for that reason. And as to the latter issue, Justice Sotomayor essentially said, Geduldig is one of the most ridiculed Supreme Court cases ever. She quoted Justice Ginsburg that the case was wrong when it's decided and wrong today. She said the whole point of this law is to discriminate against transgender individuals. I mentioned Scrimetti at the beginning because I think there's a direct relationship between what the Supreme Court did there and the cases on the docket for this term. The first of the cases for this term is Childs versus Salazar. It was argued on October 7th, second day of the term. Colorado adopted a law prohibiting so-called conversion therapy for gay, lesbian, and transgender youth. This is therapy that's designed to change somebody's sexual orientation or gender identity. The Colorado legislature found that such prohibitions of conversion therapy are justified because conversion therapy is unsafe and ineffective. A challenge got brought to this by a therapist who wished to engage in this practice. She said it violates her freedom of speech to prevent her from trying to engage in conversion therapy. Now, it's notable that the Colorado law went into effect in 2019, but nobody has ever been prosecuted under it. The law has never been used. But nonetheless, this therapist brings a challenge. The United States Court of Appeals for the 10th Circuit, in a 2-1 decision, upheld the Colorado law. The majority stressed the appropriateness of deferring to the Colorado legislature when it comes to making decisions with regard to medical care practices. The majority said that this is regulating professional speech. The law often regulates professional speech. Doctors have to give warnings before they provide medical treatment or prescribe drugs. If a therapist knows that a patient is likely to harm someone, the therapist has to warn that individual of the harm. The 10th Circuit said this is similarly the government making a choice about what medical care here, what kind of therapy is appropriate. Judge Harris Hartz dissented on the 10th Circuit and said this is a content-based restriction on speech, strict scrutiny, and the law should fail. I'll be interested in what Kim thinks, but my sense of the oral argument is that the Supreme Court is likely to reverse the 10th Circuit and strike down this statute. Maybe the court will remand it for additional evidence or concern about ripeness that's never been used. But my sense was that the conservative justices on the court here very much agreed with the dissent from the 10th Circuit. And I compare this to Scrimeti in that in Scrimeti, the conservative justices said we've got to give deference to the Tennessee legislature. I don't think we're going to see the same deference by the conservative justices to the Colorado legislature. The other cases that I want to talk about are Little versus Hecox and West Virginia versus BPJ. They involve, respectively, Idaho and West Virginia laws that prohibit transgender youth from participating in athletics corresponding to their gender identity. What it's really about is preventing transgender girls and women from participating in girls and women's sports. The United States Court of Appeals for the 9th Circuit and the United States Court of Appeals for the 4th Circuit respectively declared these laws unconstitutional. No issues are more central to the culture wars than restricting the ability of transgender girls and women to participate in girls and women's sports. Now, it relates to Scrimeti in many ways. I mentioned in Scrimeti, the court didn't identify the level of scrutiny to be used for discrimination against transgender individuals. That issue is before the court in Little versus Hecox and also in West Virginia versus BPJ. And it's notable that in Scrimeti, Justices Thomas, Alito, and especially Barrett wrote concurring opinions saying only rational basis review for discriminating against transgender youth. Also, I think that these cases, together with Scrimeti, will give a real sense of will the Supreme Court provide any protection under equal protection for transgender individuals?
Yeah, I agree with that. And it's also interesting the way the court has continued to move away when it comes to these sort of statutory questions from its ruling in Bostock, which held that that Title VII employment protections, the federal statute that prohibits discrimination on the basis of a number of things, including sex, applied to both sexual orientation discrimination and discrimination based on gender identity. That seemed to be held up. That was argued in Scrimeti to try to advance the idea that the same analysis should be applied when it comes to constitutional protections under equal protection, and the court declined to do that. It will seems that this is an even more direct case that would run afoul of the likely court rulings here. I fear in both PPJ and Hickox. And when it comes to Salazar, one thing that stands out to me in Childs v. Salazar is that this is a free speech case. And increasingly, the court has been in cases that are really at heart religious discrimination cases. The therapist in Childs v. Salazar is somebody who is religious and who deeply believes that the best way to treat people who are suffering from gender dysmorphia or feelings of that they are gay or LGBTQ is conversion and is to try to treat them. But she's bringing this as a free speech claim, saying that it prevents her as a professional from speaking in the way that she normally would do it. Again, to the standing and ripeness issue that Erwin brings up, she does not identify any patient that she's turned away. She does not say that this has stopped her practice in any way or harmed it, but still, this challenge somehow made it there, which I find is really interesting. But I've seen increasingly challenges that are really religious challenges being made under the First Amendment's free expression case. We saw that with a couple years back with a case involving a flag on Boston City Hall, that the city had a policy of opening anybody to request a permit to fly whatever flag they chose. Someone chose to fly a religious flag, and that was rejected. And the Supreme Court said, no, if you open it up, you can't discriminate on the basis of viewpoint. That's a free speech objection. That was something that was really a religious freedom case wrapped up in First Amendment free speech clothing. And so I think you're only going to see that increase. You're muted, Erwin.
And
There
so
you go.
we can take the start with the question and invite other questions, but if not, we can pick up some other cases that are on the docket that we haven't talked about.
Yes.
Let me read the question. Do you have concern that the court is consciously engaged in a pattern of impeachment of Trump in hopes that he won't flout the court's positions when they move against his positions?
I am concerned um, that well, I am concerned about what might happen if the Supreme Court rules squarely against Donald Trump. He has consistently shown no compunction about defying lower court orders. There are various news organizations that are keeping track as to how many lower court orders Trump or the administration has violated up to now. That is certainly concerning if I were a federal judge, that the administration would be flouting my authority when I issue a ruling. But the Supreme Court, so far, as we said, has ruled in favor of him and not against him. So we haven't really seen that. I do think that the justices are aware, for the sake of, as I said, holding on and protecting their own power, of the possibility of that and what that would mean if he does defy them. And perhaps that is one reason why they are stepping very carefully and handing down rulings that would be less likely um, to be defied, but I think we'll really have to see that test. I think perhaps with the Cook case might be one of them that we see that with. But I am concerned if President Trump does not think that a Supreme Court ruling applies to him, as Justice Barrett recently said in remarks, they only have the ability to issue opinions. They don't have the force to go out and enforce them. So we'll see.
I agree with everything you just said. To begin with, I share your concern that there could be defiance of court orders. President Trump said this year, and I quote, "He who saves the public violates no law." Vice President J.D. Vance said on a number of occasions that the president doesn't have to follow court orders that limit the president's powers. And if the president defies the court, there's relatively little the courts can do about it. Um, Somebody can be held in criminal contempt if they violate a court order, but a president can't be criminally prosecuted for anything he does with his official duties. That was Trump versus the United States a year ago. And the president can pardon anyone, including for criminal contempt. There could be civil contempt where somebody is put in jail until they are fined until they comply with a court order. But civil contempt is enforced by the United States Marshals, and they're controlled by the Attorney General, Pam Bondi. Well, I share this concern. You then get to the next step. Do I believe that the Supreme Court is refraining from limiting the president out of concern that their orders might be defied? And I don't know. The pattern is that the Supreme Court has overwhelmingly sided with President Trump in virtually every one of the cases that's come up on the emergency docket. Is that because they agree with him on the merits, or is that because they're afraid that they'll be disobeyed? I don't know. There's no indication from the justice in the majority. Virtually all of these have been 6-3, occasionally 7-2 in terms of the dissents. I had thought over the course of the summer that maybe the Supreme Court was going to draw a distinction between separation of powers cases and individual liberties cases. And maybe we would see a great deference on the part of the court when it came to separation of powers issues, like the removal power that Kim was talking about. But when it came to individual liberties, the court was going to draw a line. And then on Monday, September 8th, the court handed down Nome versus Perdomo. This involves the federal district court judge in Los Angeles, Judge Frimpong, who had found that ICE agents were stopping people without reasonable suspicion, using impermissible factors, and enjoined them from using apparent race or ethnicity, language or accent, what kind of job somebody has, or where they were found. The Ninth Circuit did not stay the preliminary injunction and wrote a 55-page opinion, essentially upholding Judge Frimpong. On September 8th, the Supreme Court 6-3 stayed the preliminary injunction. There was no opinion from the court, not a word of explanation. Justice Kavanaugh wrote an opinion for himself. Justice Sotomayor wrote a blistering dissent, joined by Justices Kagan and Jackson. This was a case very much about individual liberties. It was about the Fourth Amendment, keeping any law enforcement from stopping people without reasonable suspicion. And yet the Supreme Court sided with Trump there. And that really undermined my sense that maybe they were going to draw a distinction based on separation of powers versus individual liberties. There's another question. Is it too generous to the court's conservative majority to interpret their seemingly endless support of Trump to be this court's version of judicial restraint, similar to Marbury versus Madison?
What do you think, Erwin?
Well, when I teach Marbury versus Madison, I always point out that Chief Justice John Marshall knew that if he'd ruled in favor of Marbury, his order would be ignored, and the Supreme Court would be forever rendered a meaningless institution. He knew he had to rule in favor of James Madison and Thomas Jefferson, but he used it as a brilliant occasion for claiming a much larger power for the court, the power of judicial review. So in that sense, one could say, well, Justice John Marshall was afraid that his order would be disobeyed. So is this court afraid. But the problem here is that when you look at all of the things that President Trump is doing, the challenge the Supreme Court, if the Supreme Court refrains from reviewing any of them, then it's basically saying the president can do whatever he wants.
Yeah. I agree with the con law expert extraordinaire.
The next question, I don't even know how to answer. From the perspective of legal theory and ideology, would you characterize the current composition of the court to be more deontological, i.e. Kantian, versus utilitarian, Jeremy Bentham Mills, in their collective view of to choose between these two normative theories?
Do you teach legal philosophy?
I don't. And I think I last read Bentham and Mills and Kant back in college, not even in law school. My answer is I think none of the above. I think this is a majority that's very much animated by the current conservative Republican ideology. Think about what conservative Republican ideology is about. It's about such things as there not being constitutional right to abortion. It's about such things as substantial protection of gun rights. It's about ending affirmative action. It's about providing much greater protection for people in the name of religion. It's about not having an enforcement of an establishment clause. It's about giving the president great powers. That's the Republican platform. That's
Yeah.
where the six conservative justices are. So I don't think it's about philosophy, and certainly not a philosophy in that abstract sense. I think it's justices who were put on the court to implement a conservative ideology, and that's what they're doing.
Yeah, I think that that's true. And it just, when I go back to covering the Chief Justice's confirmation hearings, when he said the job of a Supreme Court justice is to call balls and strikes, the court has gone so far afield from doing that. It's really difficult for me when asked after years of saying no. The court rules in the way that they see the Constitution or they read a statute, and you may disagree with that, but that's what it's about. Now it seems really difficult to defend the court against those who say that they have become legislators in robes. They are overturned precedent just because apparently they disagree with it, which isn't the standard. And to what Erwin said, they seem to have an outcome in mind and figure out the judicial path to get there, as opposed to the other way around, looking at a case and letting the law apply to the facts and inform the outcome. It's sadly the way that they seem to be going, and I don't see how that would change in any time soon.
And I apologize that we didn't get to some of the questions that just came in, but I think we're at the end of our hour. And I also know it's late where you are on the East Coast.
It is. I'm out east. But it was delightful to spend an evening with you, Erwin, as always.
Wonderful to do this with you as well. Thank you so much. And thanks to the Beverly Hills Bar Association for inviting us.
Thank you.